Oh, yes, sir. Thank you. Couldn't find where the voice was coming from.
All rise for adjournment.
Thank you, Deputy Gordon. You all may be seated. Good morning, ladies and gentlemen. Happy Tuesday. Thank you for joining us on time. We, the lawyers, and I had to work through a few final points before they could be in a position to make their summations or closing arguments. It's important that the lawyers know the law that I'll be giving you because they are entitled to talk to you about that a little bit, maybe try to explain it. I don't get to stop my legal instructions and say, here's what's meant by X. There's a certain set of language I need to use when I'm instructing you on that. So here's what's left. In a moment, you'll get the closing arguments from the attorneys. Reminder, what the attorneys say is not evidence. This will be an effort of the attorneys to persuade you to decide the case in their client's favor. And they may highlight what they think the evidence has shown, what witnesses had said, et cetera. Of course, it's your recollection of what the evidence is and your evaluation of the evidence that will determine the verdict in this case. When the attorneys are done, we may take a break. We'll see what time it is, but then I will need to give you the jury charge. I'll read to you the law that you must apply to the facts as you find them to be. And you'll be off and running. You will begin your deliberations over in 8F. You'll get all the exhibits that were admitted. It's a big stack. And you'll have your notes and your recollection of witness testimony, and you'll begin your work in terms of the deliberations. The plaintiffs have the burden of proof, and so they have the ability to open and close of the first word and the last word with their closing arguments. It's my understanding, Ms. O'Neill, that you are electing to simply have the last word, not first and last, but just last. Is that correct?
That's correct.
All right, that means then that Mr. Kendall has the opportunity, should he choose to do so, to present the defendant's summation in this case. Mr. Kendall.
Thank you, Judge. Ladies and gentlemen, as I told you from the beginning, I have the honor and the pleasure of representing Mr. Donnie Hyder over here and his wife, Selma, who's seated right there. They've been here throughout this trial. I always start out with thanking the jury for their participation. We have a unique system in this country that allows for jury trials, citizen participation, if you will. So we thank you, my clients, thank you for your participation. You come here, you don't get much money, you take out of your time, you hear the case, and as far as I can tell, throughout this trial, you guys have been very attentive. And for that reason, I'm not gonna stand up here and go through 200 some odd documents that were introduced in this case, or roughly 200 documents that were introduced in this case over the last 4 or 5 days. I am going to highlight certain particular documents that I think you ought to pay particular attention to, because those documents, I believe, are the ones that really turn this case. And there are only about 5 or 6 of them. I don't think you need 200 documents to decide this case. This is not some complicated situation. This is a case that deals with 2 sets of people who got crossways with each other and decided to resort to the courts to settle their differences, which of course they are perfectly fine to do. There's no problem with suing a particular person if you cannot resolve the dispute that you have with that person in any other manner. And that's what has happened here. And as you've also heard, this case started out with my client filing a claim on a promissory note. That claim has now been dismissed. The defendants filed a claim against him in return. That's the claim that you are now here to decide. There are four elements in this claim. Number one is fraud and inducement. Number two is conversion. Number three is unjust enrichment. And number four is promissory estoppel. Now, I'm going to talk a little bit about each one of those. Each one of those has a separate set of what we call elements. An element is what a party has to show in order to carry their burden of proof on that particular claim. So, for example, fraud has 5 elements. And the other claims also similarly have separate elements. It's the burden of the plaintiffs to carry that burden of proof on each and every element of the claim that they have made by a preponderance of the evidence. The judge is going to charge you on the law. He's going to charge you on what each one of those claims must show. Each one must be proven by a preponderance of the evidence. What does that mean? That means that if you, and lawyers use this all the time, and you've probably heard it before if you've ever served on a jury, but if you envision the scales of justice, if one side weighs more heavily than the other, then that party has carried their burden of proof. Our contention in this case is that you will not be able to find that the plaintiffs carried their burden of proof on each and every element of each and every claim that they have made. And because they have failed to carry their burden of proof on each and every element, you will not be able to find for them and award damages on that particular claim. And it's very important that you look at each and every element. You remember the testimony, you remember the exhibits, you'll have them out with you, so you won't have to do too much memorization of the exhibits, but you'll have those exhibits out with you. And you'll find that there's 2 types of evidence in this case: testimonial evidence and documentary evidence. The documentary evidence are the exhibits. The testimonial evidence is not what I say. It's not what Ms. O'Neill or Ms. Tucker says. It's not what the judge says. It's what the witnesses say. And we've had, I think, about 7 witnesses in this case. Hasn't been a long case, but we've had 7 witnesses, and what they have said is the evidence. There's going to be talk about credibility of witnesses. And the judge is going to charge you on that. Well, your responsibility is to determine the credibility of each and every witness that has appeared here in this trial. You and solely you have the authority to determine credibility. Now, witnesses' credibility can be attacked. Witnesses' credibility can be impeached. It's for you to determine whether or not that witness has been impeached or if they have credibility, and to find accordingly. If you find that that witness does not have credibility, if you find that that witness has an interest or a bias or is interested in the outcome of the case, then you will be authorized to diminish that witness's credibility. Now, burden of proof. We don't have the burden of proof. We come into this proceeding having to prove nothing. A defendant does not have to prove a thing. Only the plaintiff has the burden of proof. Only the plaintiff has the obligation and the responsibility to prove each and every element. Some of you may be wondering why Mr. Hyder didn't take the stand. He didn't have to. He's available. Either party could have called him. Nobody chose to call him. We chose not to call him because we don't think they have proven their case. Therefore, you would be authorized, regardless of whether he testified or not, to rule in our favor because they have not proven their case. We had no obligation to put up a single witness or a single document. We had no responsibility whatsoever. The burden is entirely, completely, 100% and absolutely theirs, not ours. So each and every element of this claim, every claim that they have filed, is a claim that you must find that they have met the burden of proof. Now, I have a short demonstrative presentation that I want to tee up here. May I do that, Judge?
Please.
Got it up on the screen.
So you need to go into the Zoom. There you go. And share screen.
Okay.
There you go.
Thank you, Judge.
You're
I'm
welcome.
just talking about the preponderance of the evidence. And there you go. Excuse me, the burden of proof. And that pretty much, that screen pretty much summarizes the burden of proof. If the plaintiffs fail to prove that case by preponderance of the evidence, then your verdict would be in favor of the defendants without any monetary recovery. I just talked about the evidence. Evidence takes two forms: witnesses' testimony and admitted exhibits. Credibility of witnesses. You and only you as a juror determine credibility. You look at the manner of the witnesses testifying, the probability or improbability of their testimony, and their interest or lack of interest in the case. And you may have considered evidence offered to attack credibility. A. Vaknin, I want to talk about his testimony a little bit. Mr. Vaknin was the first witness. Mr. Vaknin signed a document in this case to start this whole series of events. And that's going to be our defendant's number 30, which was an offer to purchase. And I think it's also the plaintiff's exhibit number 30. That's a handwritten document. And the testimony was that Mr. Hyder went to New Jersey, and he and Mr. Vaknin had a discussion. And as a result of that discussion about purchasing the Verbena Street properties, this document was executed, and there was a payment of $5,000. Now, Mr. Vaknin was called by the plaintiffs. Now, Mr. Vaknin, in my view, was the most puzzling witness that you've heard from. And the reason I say he was the most puzzling witness is because he testified that he owned this property for 6 years. He also testified that in the 6-year period that he had owned this property, he had only received 2 offers. And you've heard about the condition of the property while he owned it for those 6 years. And lo and behold, Mr. Hyder shows up on his doorstep and offers him 1.1 million, which is the amount that was in Exhibit 30, pays him $5,000. Mr. Vaknin said he's mad because Mr. Hyder didn't close the deal within 15 days, even though the document he signed says 60 days. Well, Mr. Hyder didn't close the deal in 60 days. He closed it in 86 days. Now, he was an angry witness. He even accused Mr. Hyder of being a criminal. You heard that from the stand. Now, if I've owned a slumlord, rundown, drug-infested, dilapidated property, paying taxes on it to the city of Atlanta and Fulton County for 6 years, and somebody shows up at my doorstep and pays me 1.2 million, not the 1.1, 1.2, got another $100,000. Pays me one that I haven't paid the taxes on. Offers me $1.2 million on a property I've been holding and can't pay the taxes on for 6 years. And then he's the bad guy. I just don't understand it. I tried. And you could, his anger was palpable. Even though he was up in New Jersey, you were looking at him on the screen. He was almost like he wanted to jump out the screen and grab Mr. Hyder by the throat. I just don't understand how it is that a man has been owning this property for 6 years, had 2 offers. Somebody shows up out of the blue and offers him 1.1 and then pays him 1.2 in 86 days, and he's a bad guy. And that's that witness. He was their first witness. He was the guy that they led off this case with because he was so angry. I just don't get it. I don't understand it. But that was his testimony. The next witness we heard from was Mr. John Dalton. Now, I told you, I'm not going to put up 200 exhibits, but I do want to show you this one. Now, this is the only document that is signed by Mr. John Dalton prior to the closing on this transaction, which embodies the agreement between he and Mr. Hyder. Now, I want to point out several things. Number one, this thing says the seller is Atlanta Beverly Inc. The reason that's important is because Atlanta Beverly is a corporation. Mr. Hyder, and you're going to look back at exhibit number 30. Mr. Hyder treated this situation as a purchase of a company. And you're going to see several documents that have been introduced where this deal initially, and Mr. McGuire testified about this too, this deal was initially set up not as a land transaction where you buy a piece of land. It was initially set up as a deal where you buy a company. And that's going to be, you're going to see a membership purchase agreement, which would have nothing to do with a land transaction. That's when you buy an LLC, you're purchasing the membership interest in the LLC. So the deal was, for lack of a better term, screwed up from the beginning. Because you don't do land transactions by buying companies. You do land transactions by buying land and buildings. But the parties, you know, this is a document that Mr. Hyder put together. He's not a lawyer. Mr. Dalton is not a lawyer. No lawyer was involved in putting this together. So you got these documents out there floating around that really don't reflect the intentions of the parties. And this was the first one that Mr. Dalton signed. And then you come down to this middle of the document, so to speak, where it says property known by street address of, and then it says 2204 Verbena Street, 6 parcels / approximately 277 acres. Well, now it's referring to land, and it's referring to specific land. It's referring to 6 parcels, 277 units. And what's important here is that we don't talk about any retail properties. We don't talk about any retail properties at all. We just talk about 277 units, which from the appraisal you'll see are the apartments. Okay, then you come down, the purchase price is $3 million. The earnest money is $150,000. And the closing date is June 30, which is 60 days from the date that the offer and purchase that Mr. Hyder and Mr. Vecklin signed on April the 30th. 60 days later, roughly, would be June 30th. Then you see that the seller's signature is blank. Mr. Dalton signed it down below. Okay. Now, you're gonna see another signature on this document, a later version of this document that I'm assuming the plaintiffs will put up. And it has a signature there in the seller's signature, and it says Atlanta Beverly. And that's the name of the company. And there was testimony that Mr. Hyder signed Atlanta Beverly. Well, we don't deny that he signed that. He signed Atlanta Beverly because in his mind, he was thinking that this was a sale of a corporation. Because that's the contract is in the name of a corporation, and it was perfectly legitimate to do that. But more importantly, the reason they're going to point to this is that they want you to believe that him signing that was evidence of intent to deceive. The reason they want you to think that that was evidence of intent to deceive is because in a fraud claim, one of the 5 elements that I told you about is intent to deceive. Now, what's the counter to that? Well, the counter to that is that Mr. Hyder, according to John Dalton, told him the first time he went out to the property to meet Mr. Hyder at the property was that he wanted the shops. And he was going to keep the shops. And later on, at that first meeting, he told him that Mr. Vecklin was the owner of the property and that he was buying the property from Mr. Vecklin. So there was no intent to deceive because he let him know that he, Mr. Vecklin, owned the property in a company called Atlanta Beverly. And later on, Mr. Dalton had numerous copies of this document with the name Atlanta Beverly on, sending it out to all sorts of people for finance on the $3 million, knowing that Mr. Hyder did not own the property, that a company named Atlanta Beverly owned it, and Mr. Dalton accepted this document with that name Atlanta Beverly on it because he started sending it out to all these various people that he was attempting himself to get financing from. So there was no intent to deceive. So when they talk about he didn't sign his name to this document, he signed Atlanta Beverly, well, there was no intent to deceive. There was a layman's error in the sense that Atlanta Beverly was the owner, and Mr. Hyder was basically flipping the property out to Mr. Dalton and D2. That was not clearly documented. None of this transaction was clearly documented by anybody. Now you heard Mr. Well, I'll get to that on a minute. But here's the seminal document that's signed by Mr. John Dalton for purposes of purchasing this property for $3 million. Now, I want to talk a little bit more about Mr. Dalton's testimony before I go forward. Mr. Dalton testified, and you heard me ask him whether or not he was an absentee landlord. He denied that label, that classification. Well, he was. I mean, this whole transaction was about Mr. Dalton going to Donnie Hyder saying, I want to buy property in low income neighborhoods in South Atlanta. And he felt that Mr. Hyder was the guy to make that happen. Now, why he thought Mr. Hyder was the guy to make that happen, I don't know. Mr. Hyder had a piece of property that was listed on the internet. He met Mr. Hyder at the property. They purchased the property, and apparently they clicked. They hit it off. They rode around the neighborhoods. They looked at properties. He loved the properties. He bought the properties. He said Mr. Hyder was a great guy. He knew how to get tenants. He knew how to repair the properties, lickety split. He would turn them around when a person was moving out. He would turn them around. And he was just miraculous. He was a god. So he was great. I mean, his exact words were, "We trusted Donnie. We trusted Donnie. We trusted Donnie." They bought 7 properties altogether, 1 duplex, 8 doors. Mr. Hyder collected the rent. He reported the rent. He sent a monthly statement. They had a course of dealing whereby Mr. Hyder would put money in to make the repairs and deduct that money back out on the rent, no problem. Everything's hunky-dory. This is like a bad marriage gone bad. Okay? I mean, they were together for a year, and then the Verbena baby came and everything went crazy. People had to start waking up at night and worrying about the baby and feeding the baby and changing the baby's diapers and, all that goes with a change in circumstance. 2 people aren't ready for the change in circumstance. As long as, hey, there's no baby, everything's fine. I mean, we just loving each other. Hey, it can't be better. We trust each other. We good to go. Then the baby comes, the Verbena baby that nobody's ready for, that nobody can handle, and then there's problems. And the problems ultimately end up in divorce, as is represented by this lawsuit. Now that's this case from a 30,000-foot level. Bad marriage. One party sues another party. The other party puts in a slapback lawsuit. You sued me, I'm mad, I'm gonna sue you. There's no adult in the room. Everybody's emotional. But you heard Mr. Dalton say, if Donnie hadn't sued us, we wouldn't be here. So if we wouldn't be here, then aren't we here because Mr. Hyder's case is gone? I mean, he's prevailed. I mean, Mr. Hyder's case is out the window. So why are we here? I mean, what's the purpose? If you really thought that you had been defrauded, then why would you say that we wouldn't be here, but for the fact that Donnie sued us? So you were willing to forego the fraud. You were willing to forego the unjust enrichment. You were really willing to forego the conversion claim. You were willing to forego the unjust enrichment. You said that you wouldn't be here. We just wanted to buy our piece. We gave him $100,000. We thought we were going to buy our piece, and we would never. We just wanted to be done. Well, you are done. You won. You won the lawsuit. So why are we here? Well, there's one answer to why we're here. And Mr. Dalton told you why we're here. $5 million. He's got 5 million reasons to be here. He got 5 million reasons to be. That's the reason we're here. And 5 million comes in place, a lower place in this case. When I asked Mr. Dalton, how much money did you expect to make when you did this deal? He said, well, we had $3 million we had to pay out. It was going to take $7 million to renovate the property. And I think the property was worth $15 million. Well, what does that leave? $5 million. He's still trying to get his $5 million. But this time he came in here, instead of getting it out there in the marketplace with and competing in the apartment market business and renovating this apartment, doing all the hard work, he now decided, well, I can just come to court and get it. I can just corral up me 12 jurors and get it that way. And that's what's going on here. He's still trying to get $5 million. That $5 million is what motivated John Dalton to pay out that money to Donnie Hyder from day one. And it was, who would do what he did? No one. I know he's a doctor. I know, the reputation of doctors is not that they're good business people. But who would do what he did? Who would pay out the kind of money in the way he paid it out without any due diligence, any ordinary care, any justifiable reliance? Justifiable reliance, that's another element. It's another element of fraud. Justifiable reliance. Can you say that he justifiably relied on Donnie Hyder to go out and put together $10 million to purchase and rehab this property in 60 days? Abe Backman had handled this property, had this property for 6 years. But Donnie Hyder he expected Donnie Hyder to go out and get the money to renovate this property, to buy this property, $10 million in 60 days. And I want you to look at exhibit number 32. That exhibit number 32. I don't have it up on the screen. I'm not going to put a bunch of documents on that screen. But I want you to look at it's in evidence. That's the appraisal that he says he got. I asked, he was mistaken on the date he got it. He said first he got it when he first went out there, but then he realized that wasn't true. That the appraisal was document dated May 17. So he couldn't have got it the first day because he went out the first week. But he did have it. That appraisal says the time to dispose of this property is 1 year, 12 months. The professional that put that appraisal together said you won't probably be able to do anything with this property for a period of 12 months. Now that's a real estate professional who does appraisals, who's telling the person that's reading the appraisal that this property is in such bad shape that the expected disposition transfer date of this property, the marketing period for this property is 12 months. And he had that document. So how is it that he is justifiably relying on Donnie Hyder to pull a rabbit out of the hat within 60 days? It's just not possible. No rational, reasonable person would think that Donnie Hyder, a residential house flipper, the only thing you got experience with Donnie Hyder on, the man that you met on the internet, the only experience you have with Donnie Hyder is that he can flip houses and he can get tenants and flip houses and he can go in and renovate a flipped house and get it ready to go out on the market. And he's great at that. We trust how he's great. We trust him. But now you're gonna all of a sudden feel that Donnie Hyder can go out and get you $10 million. And on that point, Mr. Dalton testified that he and his partners, his medical team partners, own a $16 million building that they built from scratch. He's got more experience in developing commercial property than Donnie Hyder ever had. But he wants you to believe that he relied on Donnie Hyder and it was just a situation of misplaced trust. It just doesn't fly. Then we come to the fact that, you know, his friend, Dr. Fowler, he went to Dr. Fowler when Donnie Hyder couldn't come up with the 10 million. We went to Dr. Fowler for what we would call in real estate business a bridge loan, $2 million bridge loan. Basically to hold the property until such time as the permanent financing could be sought and received. Well, Mr. Fowler gave him a year. Originally it was 6 months. If you take Mr. Fowler's testimony, it was 3 months. However long it was, he didn't foreclose on the property until September the next year, 2017, after they closed the transaction in July of 2016. Throughout that period of time, from July of 2016 to July 2017, these parties were out trying, beating the bushes, trying to get financing for this project. Didn't happen. Fowler finally pulled the plug and the property was foreclosed on. We heard from Brian Dalton. Well, Brian Dalton didn't really testify a whole lot about a lot. So I don't really have a lot to say about him. But I do want to say this about John Dalton's testimony. Mr. Dalton testified that after the 60 days had expired, he and Donnie cut a second deal, a verbal deal. That was a phone call at which it was discussed that, well, let's see if we can get Mr. Fowler to just lend us $2 million. They talked to Mr. Fowler. Mr. Fowler agreed to the $2 million. And then you remember I questioned him about, well, what was the deal after the initial deal didn't happen? And he said, well, the deal was that it was $3 million purchase price. Fowler was going to put up $2 million. Donnie got a $1 million note. And Donnie's benefit would be that we would deduct the $1.2 million. The $1.2 million that we were paying the aid back fee would be deducted. And then we would also deduct the closing costs. We would also deduct the carrying costs. 3 million minus 1.2 million minus whatever carrying costs were, minus whatever the closing costs were. The difference or the delta is Donnie's benefit. That money would go to Donnie. So what happened at the closing was 3 million, 1.2 million, closing costs, the loan that Fowler had paid out previously, the $320,000 loan came out. The difference was $457,000. That money went to Donnie Hyder. And if you recall, I asked him, well, is there anything in writing about this? No, we trusted Donnie. We trusted Donnie. Well, why didn't you get it? Well, I know, we should have done a lot of things. We trusted Donnie. Well, is there anything, any emails? No, there's no email. What about the 187 pages of text messages from day one to day end, alpha to omega? What about the 100? Is there anything in the text messages? They came up with some text messages. The text messages, and I'm paraphrasing, said, Donnie, what about who's getting the 457? Donnie Hyder. Me, of course. But what about the carrying costs? Aren't you gonna pay the carrying costs? Yes, if there are any. This whole deal is about the 457,000 and about Donnie Hyder receiving that plaza with those shops. $457,000 is what Donnie Hyder got out of that close. The only documentation, the only agreement, the only communication whatsoever in this entire transaction about that between Donnie Hyder and John Dalton is a couple of text messages. That's it. So all of these claims, fraud, unjust enrichment, conversion, is based on some text messages and a misunderstanding of text messages and what the definition of carrying cost is. The other fraudulent thing that Mr. Dalton is basing his claims on is that he says that he should have gotten shops. He said he had a misunderstanding. He admitted that he was wrong. You heard it from the stand. He said, I was wrong. He said he thought shops meant you take the buildings, you take the income from the buildings, you manage the shop, you do everything, you tenant them up, all of that, but I own the land that's underneath. Where he got that from, I don't know. I asked him. He said that was what he thought. He didn't understand. He didn't understand about parcels. It was not his understanding. But yet and still, he had more experience developing commercial property and dealing with tenants and all of that, because he testified he did a medical building for $16 million and they got tenants in the medical building. Let's go down to our next witness, Mr. Fowler. Okay, Exhibit 263. That's the defendant's Exhibit 263. And that's going to be a deed, a foreclosure deed. Foreclosure deed is going to look like this. You won't be able to see it. I don't have it on the screen, but it's a foreclosure deed, and that foreclosure deed was filed in the Fulton County Clerk's office on September the 5th, 2017. Okay. The other important part of Mr. Fowler's testimony was that Mr. Fowler testified that in September of 2018, he sold that property as is for $3.6 million. He did testify also that he cleaned it up. He said he spent a bunch of money cleaning the property up. And he cleaned the property up and took out dump truck loads of debris. And based on all of that cleanup work, and there's gonna be, I think, some pictures in the evidence. They're gonna be at 290, which are these pictures. And he says that these pictures are how the property looked after he cleaned it up. He said he took 1,000 tires out of there. Wow. He said, I think he said he took 70 dump truck loads of stuff out of there. And he cleaned it up, put a fence around it. He said, because there's all kind of people living in there. And he sold it for $3.6 million. And I said, well, how much did you ultimately get out? He said, oh, a few $100,000 or so after I backed out all the expenses. Well, there are a couple of documents here that are not disputed at all and are clear as day. Robin Fowler had a note and a security deed that was signed by D2 Properties for $2 million. It was their responsibility to pay that note, the $2 million. Donnie Hyder, of course, is disputed as to who had the responsibility to ultimately get the finance. We say both parties were working together to try to get it. Donnie Hyder had no agreement, no contract to get financing. He never agreed that it would solely be his responsibility to get financed. And in fact, the evidence showed that all of these parties were trying to get financed. All of them were doing what they could do to get financed. It was just an impossible task, and it was unreasonable and certainly not justifiably relied on Donnie Hyder to get that money. But in any event, they had an unmitigated obligation to Robin Fowler to pay him $2 million. And they didn't do that. Now, let's go back to the agreement that we said that was cut. After the first deal didn't go through in 60 days, that deal was, Donnie, you take the 457, you pay, according to him, Mr. Dalton, you take the 457, you agree to pay carrying costs out of the 457 going forward. He said that he didn't pay the carrying costs. Okay, he said, there's a dispute about that in terms of who was responsible. Well, Mr. Fowler unquestionably wanted his $2 million back. He gave an extension. He gave a second extension. He gave a third extension. And then after he gave a third extension, he basically decided that, well, I've had enough. I'm just going to foreclose. And then you heard from Mr. McGuire. Okay, now Mr. McGuire, in June of 2017, sent this text message to Mr. Dalton. You know, and you know, they were friends, and you know, I understand how that is between friends. We go into business with friends. Things don't work out sometimes, and the friendship goes down the tubes with the deal. And then Mr. McGuire sends this text message to Mr. Dalton. And Mr. Dalton sends a text message to Donnie Hyder. Basically, he said, in order to protect Robin, we're going to do a friendly foreclosure. And he tried to explain that, what he meant by friendly. And then he says he wants to wash the title clean. Well, washing the title clean means that, and you heard Ms. Kimbrough testify about this, that means get rid of the subordinate liens. Get Donnie Hyder out of the way. And it's friendly, we can just get him out of the way. And then we can go do this deal. And I'm willing to give you 50% of the deal. That's a contract that's going to be out in evidence. Well, after this in December, after the foreclosure in September, we roll around to December, John Dalton is negotiating, he's placating Donnie Hyder. You know, Donnie Hyder says, man, these guys are for it. Why don't you sue this guy? He won't sue Robert. Now, he had no problem suing Abe Bagman. He had no problem suing Crystal Kimbrough. He had no problem suing the Victoria Group. But he won't sue his buddy, Robin Fowler, who foreclosed on the property. So Sam says, let's just have a friendly foreclosure, wipe the title clean, get him out of the way. I'm still working on the buyers, you know, I'm still working this deal. I'm pitching a guy in Miami. All of this. And then later on in December, what do? They sign a formal real contract. It's in the record. Whereby D2 is gonna buy the property back from Fowler for $3 million. Okay, all this time, Mr. Dalton is still finagling and working with Donnie Hyder to get the money together. You know, even though at this point, he's paid out all of this money that he now says was fraudulently taken from him. He's paid out all of this money that he says he shouldn't have had to pay. The title was unjustly enriched. This is in December 2017, but they're still working together to get this deal done. So all of this stuff that has gone in the past doesn't make a bit of difference. We still like this. We're gonna get this deal done. I'm gonna get that $5 million come hell or high water. Because if we can get this deal done, I get $5 million. Because that property is worth $15 million and I'm gonna have $10 million in it. And we're gonna get this deal done. So Donnie, you my buddy. You're still my buddy. Even though we've gone through all of this and I paid you the $457 back in last year in July of 2016, I paid you that, even though you told me that you're gonna pay carrying costs and you didn't pay any carrying costs. None of that matters. I don't care. We're gonna get this $5 million. We still Ace Boone Company. We like this. That's what he said. That's what happened. Then what happened? February of 2018 rolls around, Mr. Hyder says, no, I just want my $1 million note. All the time, Mr. Dalton is taping it. He doesn't know anything about it. 12 hours of tape. They played 10 minutes. 12 hours. Now, who does that? Who tapes their business partner? So repetitious. 12 hours worth. I don't get it. I don't understand. February rolls around. This lawsuit gets filed. This document I got up on the screen right now relates to Ms. Kimbrough. This is the document that after the property was foreclosed on and Mr. McGuire needed to clean up the title, he found this document. And the plaintiffs brought this out yesterday as a gotcha on Crystal Kimbrough, but it ended up backfiring. The reason it ended up backfiring is because when it was brought out as something that she did wrong, they were basically trying to throw blame on her. But that part down there, this is going to be plaintiff's trial exhibit number 12. You're going to have that out with it. But what Ms. Tucker didn't realize is that this document was stamp filed on October the 5th. Excuse me, October the 11th of 2016. Ms. Kimbrough's documents went in and were filed a record in September of 2016, which means that this document that became a lien on the assets of Atlanta Beverly was after her filing, so it didn't take precedent over her filing, so it was a nullity in terms of the work she did and her title. And you're gonna see that there was a document in the file that they brought out where there was an email from Ms. Kimbrough to Mr. Sam McGuire where she says the title was clear. It was a truthful statement at the time because this document had never hit the record. But what happened? Mr. McGuire used this document to slam Ms. Kimbrough. The Daltons sued Ms. Kimbrough, claiming that she had done all kinds of stuff wrong. And they were basing it on this document, which is a nullity, and they still basing it on it, and they brought it out in this trial. That's how, when the marriage goes down the hill, when the Verbena Street baby was born, and the marriage started going off the rocks, it gets vindictive on everybody involved. The mother-in-law, the father-in-law, all these people start getting slammed. And Crystal Kimbrough is like the mother-in-law. She was the one that did the clothes, so she got slammed. Unjustifiably slammed. Caused her to lose her title company affiliation. Did they care? Absolutely not. Because when it was no longer possible to think that they were going to get the $5 million from this deal, then everybody became a bad guy. Everybody else became a bad guy. So now it's reverted to you. They depended on you to get the $5 million. They depended on this jury to get the $5 million. Okay, now how are they planning to get the $5 million? Here's how they plan to get it. Four buckets: fraud and inducement, conversion, unjust enrichment, and promissory estoppel. That's how they planning to get the $5 million. Okay. All right. So let's go to the first one. Fraud. Okay. Now I told you about the elements. Okay. I told you about the elements. These are the elements of a fraud claim. First, you got to have a false representation. You know, I asked Brian Dalton and John Dalton, what are the false representations? Show me the false representations. He said, well, Donnie said that Abe Wagner had to go, he went to Israel and had to go to the embassy. Now, wait a minute. Why would Donnie Hardy, that was the delay. You remember that was the delay they went and paid the money on July the 13th? Robin Fowler dispersed his money, the $2 million, but they really couldn't get the deal closed until like July the 26th. Because he went in the office on the 13th and signed all the documents, but they couldn't actually close it out because Abe Wagner was holding up the deal. And Donnie told him that he was trying to reach Abe, and Abe was out of the country in Israel. Now, why would Donnie Hyder, who is getting $457 out of this deal, why would he lie about that, about Abe Wagner? Because that's holding up his money. He had no interest in not getting this deal closed because he wanted it closed. Then they said, well, Donnie made some other false statements. Well, what were they? Can you show them to me? You got 187 pages of text messages. Where in the 187 pages of text messages is there a false representation? He couldn't point to it. Where in the 12 hours of tape conversations, where is there a false representation? You got 12 hours worth. Surely, if this man is lying and deceiving, there's something in this 12 hours that's going to show some deceit, some misrepresentation. Where is that? The stuff that they played didn't show that. Are there any emails? Show me a document. where there's a misrepresentation. Didn't happen. Intent to deceive. Where is the man told you, he went out to the site, met you on the site, you know or knew that he did not own the property, even though he said, oh, this is mine. That's just puffery. That's just grandiosity. People just out, you knew it wasn't his. You had been dealing with this man for over a year. He never mentioned it. He called you up one day and said, hey, this what I don't. No. Then he also said, well, he told me that A. Backman owned it and he wanted to sell everything. He wanted to sell apartments without the shops, but I told him, no, I'm gonna have to get everything. And you got to sell everything to me. And then they went down the road together, and he later found out that A. Backman's deal was for 1.1, 1.2 million and all of that. This was all before the deal closed. He knew all of that. So there's no intent to deceive. We lacking in that element. Where is the intent? Now, plus you knew this man all the way into, you were working with this man all the way into December of 2017, 4 months, almost 4 months after the deal didn't close. I mean, after the deal was foreclosed on. You've known all of these facts. There has to be some intention to induce the plaintiff to act or refrain from acting in reliance on some false representation. And then most importantly, there has to be justifiable reliance by the plaintiff on false representation. Justifiable reliance. What is that? That means that I'm justified in believing whatever lie you told me. If there was a lie, if you find that there was a lie, that Donnie Heider represented some material issue in this case, then you also have to find that John Dalton, Brian Dalton, and D2 were justifiably relying on that to their detriment. So there has to be some damage to the plaintiff based on the lies that were told. Now, before you can find fraud, you have to find that there was diligence. And the judge is going to charge you on this. And so in order to find fraud, you got to find that Mr. Dalton, John Dalton, Brian Dalton use ordinary care. That they use care to prevent any loss that they are claiming that they have experienced in this case. It's not there. They admit that it's not there. They told you from the stand that they did not use ordinary care, that they did not do what they were supposed to do to mitigate or to prevent any loss or to protect themselves against any loss. They told you that from the stand. And if you believe them, which is not hard to believe because obviously they did not use ordinary care. If you believe them, you cannot award them a dime on their fraud claim. Not 10 cents on their fraud claim. Okay, now let's go to the next element of fraud. Concealment and misrepresentation. Concealment of a fact is not fraud unless you can find that concealment was also paired with the intent to deceive. We say there is no intent to deceive. These parties went out there, tried to get a deal done. The deal was over their head. Both of them, everybody involved. The deal was over their head. Everybody was out there trying their best to get this deal done. There's no question about that. They were trying. I asked Mr. Dalton, did Donnie sit down on the deal? Did he take the money and run? No. He didn't. He was out there trying to get the deal done. It was over his head. It was over everybody's head. This is a complex commercial real estate deal on a property that's been sitting vacant for who knows how long. Did the lenders want to touch it? Absolutely not. Now, they went to some people who I think were just shaky finance people that'll take your money and tell you they're gonna get some stuff done, but when you're in a desperate position, as they were, you try anything, you throw anything against the wall. And they did, foolishly in my opinion, but they did. The defendant, I'm gonna go back to that. Stillman. Second part of that is that in order for this defendant to be liable for fraud, the defendant must knowingly make a false misrepresentation. Okay, now let's go to the next claim that they have, conversion. Now they claim that Mr. Hyder converted their money from the rental payments. Now, Mr. Hyder would put together monthly summaries of each and every month's collection. And that was just standard way of doing business. Now, they had no agreement about this whatsoever. I mean, these people were just out there flying by the seat of their pants. Nothing in writing about how the money was going to be handled, how set-offs were going to be handled against money that he was putting out for repairs, et cetera, nothing. There's nothing in writing. So what he would do, and they accepted this practice, was that he would pay the money, they would then offset against the rent the money that he took in. And that's what he was doing. So they said, well, that's okay up until the point you sued us. And then you're gonna see them sending some letters out from their lawyers saying, send us the leases, send us this, send us that. And they said he didn't do that. And therefore he converted their money. But then there's also a letter where he sent to the new management company saying, hey, I'm transferring stuff out sent to the tenants, say, I'm transferring, you guys got to go to Citywide now. That's your new manager. Well, they said that was fraudulent because the letter was worded to say that the property had been sold. But it said sold / transfer, management has been sold, however you want to interpret it. But that's not a material issue in this case. That's not a material issue in this case at all. So you see the elements of conversion there? Okay, there we go. A right to immediate possession of the property at the time the claim is brought. The defendant's possession of the property was wrongful. And the plaintiffs had demanded possession of the property, but the defendants wrongfully refused to surrender it. Up until the time that they sent a letter to Mr. Hyder, which I think was in either March or April of 2018, there had been no demand for any money based on rent. And then afterwards, well, what I should say is, if you look at the dates on the documents, the monthlies, even the ones that talk about him setting off against the promissory note, those documents were tendered to the Daltons prior to any demand by the Daltons to turn over the rent. There's one big one for $25,000, I think it is, that he set off against the promissory note. Now, mind you, at that particular point in time, the promissory note, as far as Mr. Hyder was concerned, was a valid promissory note. Even though the property had been foreclosed on, because the Daltons had done what? They had personally guaranteed the promissory note. And you're gonna see the personal guarantees in the record. So they personally guaranteed this note, and Mr. Hyder, and the note is gonna be out there too. And you're gonna see in the note itself, it says that there's a provision in the note for set-offs. So Mr. Hyder felt that he was perfectly within his right to set off against that debt, that cross obligation, if you will, the money that the Daltons owed to him at that particular time, and then go look at the date when they finally made a demand, which is an element of conversion. Plaintiffs had demanded possession of the property being money. In this case, not real property being personal property, money. So these summaries where he's made these set-offs were before they ever made a demand for the money. So we feel you're not gonna be able to find that there's a conversion here. Now let's deal with, so now we've done fraud, we've done conversion. Let's do unjust enrichment. Now here are the elements of unjust enrichment claim. We believe you have to go through each one of these claims. You have to look at each of the elements of each claim. And then you have to determine, based on what you have heard from the witness stand and the documents that will be out with you, whether or not by a preponderance of the evidence, the plaintiffs have proven each and every element of each and every claim. Okay? And these, you're gonna have these charges out with you, and you're gonna be able to go down and look at them. Okay, unjust, the defendant, Mr. Hyder, induced or encouraged the plaintiff to provide something of value to the defendant. The plaintiff provided that thing of value to the defendant with the expectation that the defendant would be responsible for its cost. Now, the only thing Mr. Hyder got was money. The Daltons got ownership of the apartment, 277 units of apartments, based on the deal that Mr. Dalton said they cut on the telephone, where Mr. Dalton or Mr. Hyder would get the differential between those numbers that I earlier talked about. And at the end of the day, on the back end, using his terminology, he would get a 25% of all income and whatever else came out of this deal. Well, Mr. Hyder, because the Daltons did not follow through to pay Robin Fowler and the property got foreclosed on, Mr. Hyder lost part of his benefit, according to Mr. Dalton, which was the 25% interest in the property. Had they paid Mr. Fowler as agreed, that property, as proven by Mr. Fowler, could have been sold a year later for $3.6 million. Okay, now according to Mr. Dalton, he wasn't worried about the promissory note because he didn't think they owed the promissory note because there's nothing there to justify the promissory note. So had they paid Mr. Fowler the $2 million, then that was $1.6 million that could have been realized because they would have paid Fowler off the $2 million, and they could have realized a sale of that property a year later, just a year later, for $3.6 million. And Mr. Hyder would have been entitled to 25%, according to his agreement. Mr. Hyder would have been entitled to 25% of the 1.6 plus the differential between the $3 million, the $1.2 minus the carrying cost, minus the closing cost. Well, 25% of 1.6 million is $400,000. So when you consider this claim of unjust enrichment, you have to consider what was justified here. He lost, they lost. They both joined together to pursue a deal. The deal didn't work out. Everybody lost. So when we talk about unjust, well, what's unjust here? When parties band together on whatever scenario they band together and everybody loses, where there is no contract to say that you breached the contract, you didn't do what you were supposed to do, and there's no and all this loosey-goosey vague stuff that's going on based on text messages and telephone conversations, nothing in writing about who's responsible for what, who's supposed to do what. Well, when it's vague and up in the air like that, well, this is what happens. Nobody knows who's supposed to do, and obligations are just out there. Can't really tell who was supposed to do what. Now, the last, and I'm about to wrap up, the last claim that they have made is one for promissory estoppel. And here are the elements of a promissory estoppel claim. Defendants, misspelled the word, made a promise or promises. So you got to determine whether or not Donnie Hyder made certain promises. We say he did. There's nothing in writing. There's no text messages. There's no emails. There's nothing on these phone calls, on these recorded phone calls. What promises are you talking about? And the defendant expected the plaintiff to rely on whatever promises he made. And then the plaintiffs relied on such promises to their detriment. And an injustice can only be avoided by enforcement of the promise. That's a promissory estoppel claim. Okay? Now, so I want to wrap up here. The judge is going to charge you about two things. One is going to be recoupment, and that's the right of the defendant to have a deduction from the amount of the plaintiff's damages by reason of the plaintiff has not complied with any cross obligations or independent covenants arising from the contract upon which suit is brought. Well, in this case, there's no formal contract. There are oral back and forth between these parties. And if you consider that oral back and forth to be a contract, then you can order recoupment if one party didn't live up to their obligation under the contract. So if they claim, hey, here's my damages I did, they're gonna say he owes them $1.3 million because that's how much money they transferred into his account over the course of this period for whatever reason. Okay? And then he's gonna claim, well, you didn't live up to your cross obligations to pay this money to Mr. Fowler. And I lost out on the differential that we talked about, as well as my 25%. Okay, and then we're going to talk about set-off. Set-off is what I just talked. You guys know the common vernacular for set-off, but you're going to get a charge, a legal charge on what a set-off is. And that's a set-off allows a defendant to set off a debt owed to him by the plaintiff. Okay, and that's basically very close in definition to recoupment. Now, that, my jurors, is this case in a nutshell. There's going to be some, the judge is going to charge you about damages. And he's going to charge you on nominal damages. Nominal damages are a pittance. Just, okay, we hear you. We understand what you're claiming, but we don't think you're entitled to any money. Nominal damages are like $1, $5, $10. We think technically you win, but legally and morally you lose. So you're gonna have that option. And maybe, somehow, maybe, you may feel that, well, the Dolphins should get some money, and you can have the option to give them a nominal damages. And then you're gonna hear about, you're gonna get a charge on sympathy. You can't be sympathetic to one party or another. This is a legal procedure. We're not here to hold people's hands or let them cry on our shoulder. We're here to determine the facts as applied to the law. So if you find that they have been damaged by the intrusion on their peace and happiness, the judge is going to charge you that you can award damages based on that basis. But this is what I would say to that. The Daltons are business people. Donnie Hyder is a business person. These people came together for one reason: to make money, period. That's it. I mean, they wasn't there because they loved each other. They wasn't there because they wanted to go out and do good in the world. They wasn't there to go out and help the impoverished and feed the hungry. They were there to feed their pockets. We are here because they're still trying to feed their pockets. And because of that, they are now claiming, oh, well, my feelings were hurt. I don't have the same relationship with my brother that I used to have. We can't go on trips together. My kids can't play with his kids like they used to. Well, guy, you got into this to make $5 million. You asked your brother to put up $100,000 because you convinced him that this was a good deal and that you guys were going to split $5 million. So how is it now you're going to come to court, take up all of this because your feelings are hurt now? Because your peace and happiness has been infringed upon. Well, you probably need to tell that to somebody else other than 12 jurors that came down here to Fulton County, took out of their days, their time, whatever business they had to do for $25 a day, to hear you cry crocodile tears about your feelings being hurt. When you were trying to get $5 million, and the reason you hooked up with this man over in the low income community of Atlanta that you wanted to target was because you wanted to make $5 million off those folks who were renting your property that you never ever even saw. And wouldn't even know if they came in this courtroom today. And now you're telling us that your feelings were hurt? I mean, it's time to get real, people. This is about people who wanted to make some money by going down to South Atlanta, picking a guy out that they thought was the guy to do the job. We trusted him, all of that. And now you're coming in here crying these crocodile tears about my feelings being hurt. Claiming that he defrauded them, claiming that he concealed stuff, that he was a deceiver, a fraudster, bringing Abe Backman in to claim that this man was a trouble because he paid him $1.2 million. Ladies and gentlemen, again, I want to thank you for your attentiveness. You listened intently for the duration. I appreciate that. My client appreciates that. I think you see the picture here. You see what's going on. You're intelligent individuals in this community. And we have every faith that you're going to bring back a just verdict. A verdict that's going to give them zero knowledge, nothing. Because that's what they deserve. Thank you.
Ladies and gentlemen, we're going to take a break before Ms. O'Neill shares a different perspective. We'll start as soon as you all can be back here. So the jurors don't use the restrooms in 8F. They do or they do not? They do. All right, let's get everyone to 8F and then please let Deputy Gordon know as soon as you're ready to come back. I'm leaving the lawyers right here. So we'll be ready for you as soon as you have refreshed in the way you need to refresh. Please don't talk about the case. You've heard one of two closing arguments and none of the law from me. Thank you. All right, you guys take a quick break to refresh, and I'll come back out in a little bit, and hopefully we'll see the jurors soon. Ms. O'Neill, you just need to have your equipment set up, ready to go. I'm sure Dak is working on it.
It's okay, you're out. I'm off your.
Do you wanna? That's,
How many shades of purple and green? Well, you know, and the thing is tomorrow, we'll fine. I'm gonna go back to my regular shoes. I'm gonna walk on the person. What? Thanks.
I almost always opinion.
I almost always use this one, because it's like this. We were using super bendy. But I never quite getting things because then I had to tear anything.
It's kind of nice when you see the people still.
I'm clumsy. And then because my first lots of time, foot is also like my brain. Sort of amazing that you want to share. To wear braces and stuff. That's how I used to teach it. Because his muscles, can give it a. You know, you're fit, right? Funnily enough, given how I grew up, the thing that I had the most was I hated it so.
Oh, that sounds right.
I know, right? The thing I hated the most was
We had respectable stripes.
So like, it was like a hoop and they had, did it all over the world.
It's really bad earlier.
It was that like 5 times, it was the third time, it was 3 times.
You can stay there, Mr. Kendall. I mean, be wherever you want until we know the jurors are ready. Be at ease. Oh, are they good? Oh, they're right here? Great. All right. Mr. Kendall, head on back. Let's bring everyone in, please. Thank you, Deputy Gordon. we need our court reporter. I don't know where she goes. So everyone can be seated, be at ease. We have our court reporter here. So I'm going to talk about scheduling. It's okay, it's not on the record. We'll see what time it is when Ms. O'Neill is done. And then I'll take your pulse as to whether you want to go to lunch before I give you the charge. My charge isn't all that long. It'll probably be 20 minutes of what I need to read to you all. You don't need to decide right now because we don't know how long plaintiff's closing is. But you may decide, Judge, we'll take a short lunch, we'll come back, get our charge, and then begin deliberations. We could also do the charge, then you get lunch, then you begin deliberations. It's going to be your call. You are very much in the driver's seat as to schedule once we're done with other closing. So just be thinking about that. Ms. O'Neill and Mr. Kendall, have you all conferred about the universe of exhibits that goes out? Or have the two sides double checked? Nope, not yet.
We have not conferred, but we have ours, and I think they have theirs.
Okay.
Shouldn't take long.
Okay.
That's it.
You good? Okay, great. So, ladies and gentlemen, as announced, Ms. O'Neill is now going to present the summation or closing argument for plaintiffs. Ms. O'Neill?
Thank you, Your Honor. I want to start like Mr. Kendall did, and I want to thank you. Without you, we can't do this, and you were here on time. Some of you were here on time and then told you couldn't come in, but you were here on time, you paid attention, you took notes, and I appreciate that because without you, we can't resolve this dispute. And up front, I want to apologize to you for how long and boring it was to listen to me to put 154 separate exhibits into evidence. I'm sure you all have burned into your brain the series of foundation questions. Is this a true and correct version of that document that you sent out or got that day? We'd like to offer into evidence, plaintiff's exhibit, whatever. That's like an hour of your lives you're never going to get back. But it's really important because it's the evidence in this case, and only the evidence in this case, that you get to base your decision on. If it's not in the evidence, you can't consider it. Mr. Kendall talked about some things in his closing that he thought was in the evidence. Not sure I agree that all of it is in fact in the evidence. You have to look at your notes, think back to the testimony, look in the documents. You get to take all these documents back in the room with you, look at them and see what's in the evidence and make your decision in this case. And there's a lot of evidence because this was a particularly long and complicated confidence scheme that was played out against my clients. It wasn't just some game of 3-card monte where they picked the wrong card and so they lost their money. This was, as John Dalton described, death by 1,000 cuts. And 1,000 cuts takes a long time to put into evidence. Last week, when you first came down to the courthouse and the judge talked to you about our burden of proof, and he told you that the standard applied is called the preponderance of the evidence. He's going to talk to you about that again when he gives you instructions later. But if you remember, what he told you generally was the preponderance of the evidence is that which would incline a reasonable and impartial mind to one side of the issue rather than the other. He talked about the scales of justice and the fact that preponderance is where the evidence is enough to tilt the scales ever so imperceptibly in favor of one party or the other. Well, ladies and gentlemen, I think in this case, the scales have funked down on my client's side based upon the evidence. And I think it's interesting that the defendants have chosen the no reasonable person would conclude that the statements that were made to my clients were truly statements of fact. It's an interesting defense. It's an interesting defense because in opening, Mr. Kendall described the deal, the Verbena Street deal, as a challenge for Mr. Hyder, not an impossibility, a challenge. And now that the evidence is closed, the argument is that my client should have known better than to ever believe Mr. Hyder could actually deliver on these promises and get financing, and that they could turn this deal around, and that they could all make a profit, not just my clients, but the defendants as well. The defense suggests that Mr. Hyder is just a small-time, single-family home house flipper. Well, that's not the Donnie Hyder that my clients interacted with. The Donnie Hyder that my clients interacted with, that Donnie Hyder, he rang the bell of NASDAQ. And that Donnie Hyder, he rang the bell of NASDAQ with Bishop T.D. Jakes and Jerome Russell. Jerome Russell being the president of H.J. Russell, the big Atlanta development company. And that Donnie Hyder knew Mr. Russell well enough to be able to pitch for seeing if he would partner with them on this deal. And Mr. Russell wasn't the only president to whom Mr. Hyder had ready access. We're looking at Exhibit 147 here. And if you look on page 20, sorry, having a little clicker problem because my internet connection is apparently unstable. If you look on page 20, you'll see that Mr. Hyder said he was selected to join the esteemed leaders of the city to host fundraising events for President Bill Clinton and other Atlanta power players. And he's not just some plus one, he is important. He's important enough that he gets to invite other people. And if you look on page 25 of 147, you'll see that the Donnie Hyder my clients were dealing with, he and his wife are on the committee to co-host fundraising for presumably the next president of the United States, Hillary Clinton. And again, you'll see he's not some random person who's involved in this. And you'll see again in Exhibit 147, the Donnie Hyder my clients knew, he vacationed with the President Obama. That doesn't sound like some small town single-family house flipper to me. That sounds like a big-time Atlanta power player. That's the Donnie Hyder that my clients thought they were dealing with. And he was someone that they trusted because he groomed them for over a year to trust them. He groomed them for a year to work on a handshake deal, to be reliable, not look too far into what he called his business. He built that confidence between 2015 and 2016. And once he was in that position of confidence and he had my client's trust, when the opportunity arose, he went in for the big payoff. Now, Mr. Kendall admitted that the parties were supposed to be business partners. Business partners are a confidential relationship. They're people you're supposed to be able to rely on and trust, not people who lie to you. And it's that confidential relationship business partners have which allows business partners to rely on one another instead of going around and checking to see if everything that each one says is true. And the uncontroverted evidence in this case is the testimony that this Donnie Hyder that's revealed in the text messages is the Donnie Hyder that my clients thought they were dealing with. The uncontroverted evidence in this case is also the testimony of John Dalton that the reason they went into this deal, the promise that was made that they relied on, was that Mr. Hyder said he could get them financing. And the uncontroverted evidence in this case is that the reason that Mr. Dalton thought that Mr. Hyder could do this is because Mr. Hyder said he's done this before, that he had gotten financing of this magnitude before. This is from the trial transcript of John Dalton's testimony last week on the 10th. This evidence is absolutely uncontroverted. Mr. Hyder had the opportunity to come in here, tell you that was wrong, and he didn't take it. So the defendant argues something other than this happened, but they didn't give you any evidence of it. None of it. They attacked us for only playing a little bit of the 12 hours of audio tape. I think none of you would have wanted to spend, that would be a day and a half just listening to that whole audio tape. But we put it all in the record. It's all right there if somebody wants to listen to it. But this evidence about what was told to our client and why they got in the deal stands absolutely uncontradicted in the record. And it's not unreasonable for business partners to believe in one another, to trust one another, to think that the man who vacations with the President of the United States is telling you the truth when he says he can get you this financing. And the fact that Mr. Hyder didn't come testify, that's something you need to think about. Mr. Kendall told you that you can judge credibility by the fact that someone has an interest in the outcome of this case. You can judge the fact that Mr. Hyder didn't come and give you that chance to judge his credibility and his outcome in the case. And you got to ask yourself why. Why not? There are some things we know for sure from the evidence in this case. First thing we know, and Mr. Kendall did bring this up, is that Mr. Hyder lied to John Dalton about the reasons for the deal not closing as it originally planned. And that's harsh. I understand that. That's harsh. But ladies and gentlemen, that's what the evidence says, that this is a lie. He told my client that there was a delay because Mr. Vaknin was out of the country, had to go to the embassy to sign some documents. Mr. Vaknin told you that's not true. Well, Mr. Hyder didn't get on the stand and tell you what was the basis for him to say that. The only thing you have in evidence is the text message where the statement is made and Mr. Vaknin telling you it isn't true. Mr. Hyder had a chance to tell you what this was based on. He could have come in and said, no, Mr. Vaknin told me that, but he didn't. And I submit to you the reason he didn't is because he doesn't want to have to explain it. He didn't want to have to answer my questions or your questions because you would get to ask questions about the basis for this. And if you look at page 25 of the 147 in the text messages, now on July 25th, I'm sorry, this is at page 61. Now on July 25th, the story is that the deal is delayed because Abe and his attorney feel like there are intrusive documents relating to the closing. Mr. Hyder might have to fly up to NYC. And by the way, if you look elsewhere in these text messages, you'll find references to Mr. Hyder's jet that he was using to fly around on this. But he might have to fly back up to NYC, and then he's back and forth with Abe's attorney now. Again, the absolutely undisputed evidence is that Mr. Vaknin believed he had an attorney in this case, and her name was Crystal Kimbrough. That's what Mr. Vaknin testified to. Mr. Hyder had a chance to come tell you who this lawyer was. He elected not to take that. You do need to ask yourselves why. At page 62 of the text messages, now we have, oops, I did that wrong. At page 62 of the text messages, you'll see that Mr. Hyder it's not up on the screen, but he's talking about that fluid situation with Abe and that he has it worked out on the 26th. And the evidence shows that what he worked out is I think I'm missing a slide. I am missing a slide. The evidence is what he worked out was he changed the deal. And he changed the deal, and you'll see this in the evidence. You can compare the HUDs. You can look at the HUD that's Exhibit 14, which is the first one that was sent to Mr. Vaknin, and it has on it a sale price of 1.1 million, and it has $127,000 owed in taxes. And then you can look at the later HUD that was sent later in July 26th, and what it has is a $1.2 million price, and the taxes are down to, they've been reduced by about 78,000. That's what the fluid situation was on July 26th that Mr. Hyder was working through. He was working the change in the deal with Mr. Vaknin. What lawyer he was talking to? I don't know. The only lawyer in the deal was Crystal Kimbrough. Now, we also know that Mr. Hyder's claim that Miss Kimbrough needed to get fees in July was not true. You heard, because we played the tape, you heard Mr. Hyder say that Ms. Kimbrough had to get more money in January 2018. That's not argument, ladies and gentlemen. That's not spin. You heard it. And this is the call, if you remember, where he said she needed 25 because her rate was $500 an hour and she had to go to counseling because she was so upset. And he discouraged, if you remember in that call, my client from calling her to talk about it. And you have Exhibit 147 at page 182, where Mr. Hyder then says, Crystal's not inclined to reduce her regular 25K rate, especially since she sees Sam always gets his rates, which are higher than hers. Can't argue with that. I'm requesting 15K for me, not my quotes, Mr. Hyder's quotes, to help out under the circumstances, although I'm not really sure it's fair to her. And you heard the second taped conversation later in that day when Dr. Dalton said he would wire that money. And you saw Exhibit 66, which shows that the money was wired, that $15,000, to Mr. Hyder on January 3rd. But you heard Ms. Kimbrough come in and say, not only did she not get that money, she never went to counseling over this whole Robina Street property deal. That's just not true. Mr. Hyder just made that up. That's why he didn't want John to call Ms. Kimbrough in January of 2018, because he'd have found out that this request for fees for Ms. Kimbrough, that was a lie. And it's just like he made up the story he sold to Mr. Vaknin about having $6 million in the bank so he, not somebody else, he could buy the property, start the renovations, get it going. Now, Mr. Vaknin told you that when Mr. Hyder stood in his living room, he said the deal would close in 15 days. And he said he didn't know when the 60 days was put on that document because he didn't care. His testimony was not very, very clear about that. But what he was very clear about was that Mr. Hyder stood in his living room and told him the deal would close in 15 days. Now, it would have been interesting to see what Mr. Hyder said about that. But I didn't get a chance to ask that question. You didn't get a chance to ask that question. And one does have to wonder why. Perhaps it's because Mr. Hyder didn't want to have to answer questions about the execution of this document. These are Exhibits 20 and Exhibit 7. Exhibit 20 is the document signed in Mr. Vaknin's living room. So that's clearly his signature. He told you it was, and it was signed in his living room. Exhibit 7 is the standard offer to purchase and sales contract, which Mr. Kendall told you was signed by Mr. Hyder. He said it was a layman's error. Ladies and gentlemen of the jury, signing someone else's name to a contract is not a layman's error. It's a forgery. You can't pretty that up. And if there's any doubt about whether it's the same signature, you can also compare Exhibit 7 to Exhibit 25, which Mr. Vaknin signed. And you have to ask yourselves, why would Mr. Hyder sign this document? Sign it for, I don't know if that says Abe Vaknin or what it says, but sign a document when he's not the seller. He had no authority to do that. Mr. Vaknin was very, very clear on that. Why would somebody do that? Well, I submit to you, it's an intent to deceive. That's why. It's so that it looks like there's a legitimate contract with some seller, when in fact, there's not. Because there was never a deal for Atlanta Beverly or Atlanta Plaza or anybody related to Abe Vaknin to sell my clients anything. So in opening, Mr. Kendall told you this is what the evidence was going to show you. He said that you were going to see that there was a friendly foreclosure. We're going to wipe Donnie out, and then you and I can sell this property, split the profits. Several months, a few months after, Mr. Fowler, John Dalton's buddy, his friend, his doctor friend, foreclosed on the property on his $2 million note. He sold the property for $3.5 million, and he made $1.5 million profit just months after he foreclosed. Well, that simply isn't true. There was never a $1.5 million profit. Dr. Fowler came in and he told you that. And he told you that we all knew that because he told it to us back in 2019 when Mr. Kendall took his deposition. But what I think is interesting about Dr. Fowler's testimony about that profit, you remember what he said? What he said was, well, I had to clean it up. Those thousands of tires I had to take out. I put some money in, put several $100,000 in, and then I was able to sell it and make a profit. Well, that could have happened with the parties to this case too, if the deal had been to just flip the property, because the defendants could have taken that $457,000 they pocketed at closing. They could have spent some of that to clean out those tires, run electricity to it, do all those things that Dr. Fowler did. And then they could have sold it for the $1.5 million profit, retired the note, and gone on their way. So Dr. Fowler's testimony about his profit simply shows the opportunity, if this was really supposed to be some flip and resell, makes that story look not quite so credible. Now, nor was there some plan or scheme to cut out Mr. Hyder's interest in the apartments. Both Robin Fowler and Sam McGuire came in and they told you, both Robin Fowler and Sam McGuire came in and they told you that there was never a plan to eliminate the interest. Both of them were asked, did you foreclose on this property in order to eliminate the interest or any interest that Mr. Hyder or Bristol Consulting may have had on the property? Both of them said no. They were asked, did whether or not Mr. Hyder or Bristol Consulting's interest might be affected factor into your decision-making? No. Did you give my client any portions of the proceeds? No. There was no scheme here. There was nothing like that. And the liens that had to be cleaned up, that had nothing to do with Mr. Hyder. That was that Exhibit 12, $6 million judgment that Brandy Harris had, the one that we showed Ms. Kimbrough, that she said didn't get filed until after the property closed, but it had been entered in the court before, just it didn't get filed as a lien on the property until after the closure. But it was a lien. It was a cloud on the title that had to get fixed. And if you look at Plaintiff 73, you will see, this is Plaintiff 73. This is the claim that Fowler Financial filed for that $6 million judgment. This is the lien that needed to be cleaned up. Nothing to do with Mr. Hyder or Bristol Consulting. Nothing at all. There's no scheme to eliminate his interest. There's simply no evidence about that at all. Now, let's talk about the property that was to be conveyed. You saw this before. You're going to have the documents that you can look at this back in the jury room. But parcels E and F on Exhibit 46, which is the deed transferring property to my client, are precisely the same as track 1 and 2 that are transferred to Bristol Consulting through Exhibit 25. The argument of the defendants is that my clients agreed to buy Bristol Consulting and Mr. Hyder this piece of property, plus give him $457,000 just to put in his pocket and take home cash. Does that sound reasonable to you? Of course not. That's because it was never the agreement. This is unjust enrichment. This is Mr. Hyder getting a piece of property he didn't pay a penny for. And that's clear, it's undisputed. Ms. Kimbrough, her ledger shows he didn't pay a penny for it. There's a $1,200 transfer tax the day that the deed needs to get filed. That's it. He didn't bring a penny to closing. My clients bought this property. Mr. Hyder was unjustly enriched by its ownership. And there are multiple documents to show you why my clients thought they were getting this property. There's Exhibit 46, the warranty deed to them, which contains parcels E and F in the property description. There's Exhibit 3, the owner's affidavit that the Vaknin signed from Atlanta Beverly, which contains the legal descriptions of E and F. There's the July 12, 2016 email that Ms. Kimbrough sent to my clients. Remember, she testified about this. This is what she sent the night before pre-closing. And she said she sent it because it was an unusual transaction. And the membership interest purchase agreement that she sent that night, it contains the same E and F parcels going to my clients. And the assignment of leases, rents, and profits she sent that night, it contains legal descriptions E and F going to my client. And the affidavit regarding the commercial real estate brokers, it contains E and F going to my clients. The UCC financing statement, it contains E and F going to my clients. But there's more. There's Exhibit 32, that appraisal that Mr. Hyder showed my client back in May. It shows E and F as being part of the appraised property. And there's Exhibit 168, which is the quitclaim deed, showing exhibits E and F going to my clients. And there's Exhibit 176, that updated appraisal, showing E and F going to my clients. And of course, there's Exhibit 39, the new market tax worksheet that we showed you which had all of the retail requirements for the tax credits that the defendants gave to my clients. Well, that document doesn't apply if we didn't get the retail parcels. It doesn't apply at all if we didn't get the resale parcels. But there's also, these are the documents weighing them together, transferring on the left side of the screen, parcels E and F to my client, one document, transferring them to Bristol. No HUD 1, no financing statement, no ledger, no entry in the ledger showing that there was a separate deal, a simultaneous closing, or anything else transferring that. And Mr. Kendall asked Mr. Dalton or Ms. Kimber, I honestly can't remember who, about, well, did anybody ever complain that the Daltons didn't get the keys to those retail properties? Did anybody ever ask, what about the rents? Well, no, they didn't ask. And the reason they didn't ask is because Exhibit 16 had a document in it called Assignment of Rents and Leases. And in that assignment of leases, rents, and profits, it includes, among other things that are being assigned to Fowler Financial, the leases and rents for parcels E and F. So the Daltons didn't have an interest in those leases and rents. That's why they didn't ask for the keys, and that's why they didn't ask about the rents. They relied upon, and they agreed, that Mr. Hyder and Bristol got to run those properties, not own, run. You can lend me your car. That is not the same thing as giving it to me. But what happened instead? What happened instead of my clients getting these documents or getting these properties? Oh, I forgot, there's one more document. This is a plaintiff's exhibit, and this is a defendant's exhibit. It's Defense 84. And this is that letter that shows that Mr. McGuire was asked about. And it shows that in August of 2017, there were loan payoffs being requested for parcels and commercial land. Commercial land. Retail parcels are commercial land. But instead of my clients getting it, what happened? What happened was Mr. Hyder took $457,000 from the closing. He took it wrongfully. He took it fraudulently and he unjustly enriched himself with it because he didn't use it to pay carry costs or anything else. He put it in his pocket, but he also got property. And I just want to talk about unjust enrichment for a minute before I go back to this. Mr. Kendall gave you kind of an equation about how the $457,000 equals the 25% Mr. Hyder was supposed to get on the back end on some sort of modified deal. First of all, it's the back end, not the front end. And I think there can be no dispute that July 2016 was the front end. But second of all, you've heard this in evidence, the court's going to tell you instructions. Mr. Hyder's claims to be owed money by my clients about the Verbena Street deal, they're dismissed. My clients never owed him any money on the Verbena Street deal. And Mr. Hyder still has the retail parcel. Bristol still has the retail parcel. Mr. Hyder and Bristol still have that $457,000. And my clients never owed him a penny. That's been determined as a matter of law. So when you look at these two documents, there's some interesting things about them. Ms. Kimbrough said her office prepared these documents, and she stood up and she acknowledged that they made a mistake and put in the wrong legal descriptions. I appreciate that. I mean, lawyers make mistakes, and she came in and she owned that. But there's some other curious things in these documents too. First is that Exhibit 25, transferring the retail parcels to the defendants, it's dated June 1st, 2016. And the document transferring parcels to my clients is dated over a month later, July 12th, 2016. And Ms. Kimbrough told you that her recollection was that this is because it was a mail-in and things were being held in escrow. But her recollection clearly has to be flawed. Totally understandable, because she testified she does about 60 closings a month. This was 5 years ago. There's a lot of closings between this one and when she got on the stand to testify. But her recollection clearly has to be flawed because the evidence shows that nothing happened before June 1st or around June 1st or on June 1st. If you look at Exhibit 4, this is an email between Mr. Vaknin and Ms. Kimbrough on June 6th, 5 days after that warranty deed is dated. And in here, it is quite clear the deal has not closed. Nothing's been signed. Nothing's being held in escrow on June 6th. And the money for the closing, that didn't come in until July 12th, almost 6 weeks after that June 1st date on Exhibit 25. And then there's the question about the deed filing. And again, just a little bit, but Ms. Kimbrough told you that date of recording, time of recording is key in Georgia. Just a little bit. The recording for Exhibit 25, transferring property to the defendants, filed just a little bit before transferring those same parcels to my client. And ladies and gentlemen, if it had been reversed, then my clients would have the superior lien on the retail. But it wasn't. So there's definitely something fishy and odd about the date on Exhibit 25 and the filing. Now, Ms. Kimbrough told you that she was getting instructions from all parties and that everybody knew everything. But the evidence again shows that that's not quite right. And the evidence shows that there are instructions which we can only conclude had to come to her from Mr. Hyder. So first, there's this instruction about that's in Exhibit 3. And you remember, we've looked at this a whole bunch of times. This is the email in 2018 that Ms. Kimbrough sends to Mr. Vaknin. And she tells him she can't show him the full settlement statement 2 years after the transaction has closed and after it's been foreclosed on, because there was a request for confidentiality. Well, everybody with skin in the game in July of 26 came in this courtroom and sat in that stand. Everybody on the buyer side came and sat in that stand, and they told you they didn't give that instruction. So that leaves one person on the buyer side who didn't come testify, who could have given that instruction. And you do got to ask yourself why Mr. Hyder didn't come and answer those questions, my questions, your questions. And conveniently, the defendants are the only ones who benefited from not letting everybody know both sides of the deal in 2016. He's the one who ended up owning part of the property that my clients undisputably paid for. And it's a property that Mr. Hyder himself thinks is valued at about $700,000 at the lower end. I'm going to play you another audio clip from those tapes that we had. Now, this one wasn't played to you before, but it's in evidence. It is marked in these exhibits. This is my big stack exhibits. And there is in here a thumb drive and a list of all those recordings. And this is in there as well. And this is what Mr. Hyder says about that piece of property that my clients bought for him.
Right, but that's not real. He's seen appraisals. He's seen everything. If he offered it out there for somebody at $2.2 million or whatever, he can sell the strip mall. Not a problem. I mean, not the strip mall, but he can sell the apartments. Not an issue. But when you suggest that he put, wait a minute, he put another $400,000 or $500,000 in it, and then he's going to buy a strip mall, which let's just say, okay, the tax value says what, 300, 350 or whatever. So of course you go a multiple of that. You would just say, okay, you say you go 700,000. So 700,000, let's just say on the lower end, 700 grand. Everybody knows that.
That's Mr. Hyder's words, saying what he thinks the piece of property he had my clients buying. And that, ladies and gentlemen, is unjust enrichment. And the fact that there was deliberate concealment about what was going on, that's fraud. And coincidentally, that parcel that the defendants ended up with is the only parcel which generates additional income, which generates income without any additional expense. It is, according to Mr. George Andrews, you remember that nice gentleman from the bank? That parcel has significant strength in and of itself. That's what their witness said. But what's even more telling, I thought, was Mr. Andrews' testimony that the fact Mr. Hyder carved that parcel out and had it transferred to himself made it harder to get financing for the deal that my clients thought they were doing, because they didn't think it was a property flip. They thought it was a development investment. And what Mr. Andrews told you was the renovation of those apartments so they could go from what Mr. Kendall calls dilapidated, drug-infested, and run down. Not really sure how much of that evidence is in the case, but that's what he called them. So they could go from that to a place where people not only could live, but they'd want to live. But again, Mr. Andrews, defendant's own witness, said Mr. Hyder having carved those parcels out for himself, well, that weakens things from a lending perspective. Makes it harder to get the financing that Mr. Hyder was supposed to get. So maybe he was out to tank it from the get-go. Maybe he didn't ever intend to keep his promise to Mr. Vaknin to get that property cleaned up and developed. Maybe he didn't intend to keep his promise. I'm going to take out maybe. He didn't intend to keep his promise to my clients to partner with them to renovate that and run it. His plan, and his only plan, was to get himself as much money for the deal as he could. And it clearly worked, because my clients didn't just buy him the retail parcels. They also paid him hundreds of thousands of dollars. And yes, they didn't dot every I. And no, they didn't dot every T. They didn't cross every T. But that's because this was supposed to be their business partner, a confidential relationship, someone you can rely on. So I want to talk a little bit about what the money, Mr. Hyder says the money that's owed to him. And again, as I'm telling you this, I want you to keep in mind, it's been determined as a matter of law, my clients never owed Mr. Hyder any money. But this is what Mr. Kendall told you in opening that you were going to see. That you would see in a document that my client's signature is on, that Bristol will sell these burnt out, dilapidated, drug-infested apartments to my clients for the sum of what? Not 1.2 million, but 3 million. They signed that deal. There's no such document and evidence in this case. Nowhere. Not anywhere in this big stack. Not a single one. Defendants had the opportunity to bring it to you. They didn't. There's 12 hours of audio tape. If Mr. Hyder had even ever said that, they could have played it to you. But they didn't. And they didn't because it didn't exist. Because my clients didn't agree to that. Now, Mr. Kendall told you his recollection of my client's testimony about what the second deal was, but he skipped to the part, and I hope you remember this and your notes show this, about how the partners were in this together And Mr. Hyder and Bristol, they were going to get rich too. This was definitely not just my clients getting rich off the backs of Mr. Hyder. They were all supposed to profit. And the defendant's sweetener, that was on the back end. My clients were going to take out the obligation, take the note, be responsible for that. Mr. Hyder was supposed to do some things, and then in the back end, he was going to get some money and he was going to get a percentage. And when Mr. Kendall was talking about that deal, he skipped the part. Well, he skipped it in the beginning. Then he came back and talked about the text message, about the carry costs, about what that $457,000 was for. So what the claim my clients owed money really comes down to are these documents, Exhibits 5 and 7. And I thought it was interesting, so we're going to talk about this, there's Atlanta Beverly Inc. Mr. Kendall said, this deal was screwed up from the beginning. Sure was. Mr. Vaknin told you there's no such company. No such company. His company's an LLC, not an Inc. And Bristol Consulting is an LLC, not an Inc. American Business Group is an LLC, not an Inc. It's a difference. So right there, this contract, the only piece of paper that has $3 million on it, it should be null and void because one of the parties to the contract doesn't exist, never existed. But both of these also say there's $150,000 earnest money, $50,000 of which shall be forfeited if not closed by June 30th. I think we can all agree it didn't close by June 30th. My clients didn't get their $100,000 back. But what's also interesting is the one that John Dalton signed, Exhibit 5, it just talks about buying the property. That second version, the one that had the seller's signature added, it adds purchaser to acquire 100% shares of the LLC. But according to the evidence in this case, the only person who ever wanted acquisition of shares in an LLC was Mr. Hyder. John didn't want it. Brian didn't want it. Mr. Vaknin told you he didn't want to sell it. That leaves one person who could have put that term in. That person didn't come here to get on the stand to answer questions that I might have about it, or you might have about it. And you have to ask yourself why. But what the evidence shows is that when whatever deal was envisioned here to profit the defendants didn't happen, then Mr. Hyder moved on and he tried a new tactic. And what is again what the uncontroverted evidence shows? The uncontroverted evidence shows that Mr. Hyder told my clients, give me $100,000 by the end of 2017, and I won't sue you. Uncontroverted. Mr. Hyder could have come in here and told you, no, that's not what it meant. No. You have it all wrong. He didn't. This $100,000, all by itself, forget about everything else, which shows fraud and unjust enrichment and inducement to get into this contract. This all by itself shows fraud. It shows unjust enrichment. This
How about
is what you heard.
me? How about our agreements?
Well, again, our agreement is subject to these other people.
Not subject to anything. There was no subject to when you said give me $100,000. There's no subject to.
John, I'll give it back.
Good, give it back.
Okay. Fine. When you want it? How do you want it?
I want it wired tomorrow.
Didn't happen. Didn't get it back. But that's not what happened. Instead is 3 days after that last payment was made, Exhibit 143 was sent, the notice of default on the $1 million promissory note. Pay me $100,000 or I'm going to sue you for $1 million. Pay $100,000. I still get sued. If that's not fraud, ladies and gentlemen, not sure what is. But that's not the only thing the defendants did to try to intimidate my clients into giving him more money. There's also an audio tape that was recorded on February 12th, 2018. And again, in evidence, not one you heard before, but I'm gonna play it for you now. It's Exhibit 134. And you are permitted to consider it in your deliberations because it's in evidence. And in there, there's a clear threat, not a physical threat, a clear threat. Do this or I will sue you. You better do this. You better do what I want. Or you're gonna have to come into court and you're gonna have to spend your time and spend your money, Dr. Dalton. You're gonna have to not see your patients. John, Brian, you're not gonna be able to go to work. You need to come in here and answer because I'm gonna sue you unless you do what I tell you.
Well, John, like I said again, man, it's pretty clear and laid out. And if you choose to, to I guess, go with that version and that whatever, then that's your privilege. But I've explained to you, my position. And there is a remedy there. There's a remedy there to make me whole. And there's a remedy there to make you whole, but you choose not to accept
Which is sue my friend and then try and sue him for damages. Sue the guy who got us, it helped us even start this whole thing. Sue that guy. That's the remedy. Sue him, or I sue you, is what you're telling me. And you sue him.
Let me ask you this: is that not a remedy?
Yeah. That's ridiculous, though. I mean, it's
okay.
Sue your buddy. Sue the guy who gave you the money, who gave you the extensions, who just gave you an equity piece. If there's a development, sue that guy. Sue him.
Okay.
That makes no sense.
Okay.
And then sue him for damages. Then sue him for another whatever. How many? Whatever. What was your damage number you wanted to sue him for?
Or whatever the damage amount is.
Yeah.
That's my position, John.
Sue. Yeah, that's using that as a weapon. All right. Well, I'm not suing.
Okay.
I'm not suing him. I'm not letting you make me sue him.
Well, I'm not making you do anything.
No.
That's just a remedy that's available.
No, you're
Like
leveraging that million.
Just like I wouldn't make you file bankruptcy.
Yeah,
that's a remedy.
You better file. I got the email that says that. You better file bankruptcy or write me a check.
Oh, sure.
Yeah, that's not.
If there's a remedy,
That's a threat.
Mr. Hyder made good on that threat. He filed this lawsuit claiming even after he'd gotten all that money you heard about in evidence, that property, which he himself thinks is worth $700,000, he wanted more. And finally, the Daltons had had enough. The bad thing John feared, the thing he had spent months and hundreds of thousands of dollars trying to avoid, it came to pass. My clients didn't think they owed the defendants any money, but they were required to hire lawyers and come into court and prove that, and they did. The claim for their money got thrown out, and having been forced into court, they did file their claims. And Mr. Kendall said, somehow that's bad. That's bad. We should have just given up. Well, I'm sorry. Do not invite me to dance and then be mad when I stay when you get kicked off the dance floor. That's just not right. That's just not right. So when you consider all of this evidence, and you look at the verdict sheet, this is what the verdict sheet looks like. I submit to you, we have proven the elements of every claim. Every element of every claim. When you consider what we've shown you. Now, Mr. Kendall poked holes, didn't do this. But you have to ask yourself, why didn't they play you any tapes? If what we have is completely wrong, Didn't Mr. Hyder one time in 12 hours say something that supports their position? Isn't there any email from him? Any text? Anything? There were a lot of opportunities to show why the evidence here, which proves our claims, isn't right. And the defendants didn't take it. And the biggest one, and I keep saying this because it's pretty puzzling, Mr. Hyder didn't get on the stand and give you or me a chance to ask questions. Everybody else did.
Judge, I've been trying to allow this to go on with Ms. O'Neill. She's made several references to the fact that Mr. Hyder didn't take a stand. But she doesn't state that she had equal opportunity to call him to the stand. We talked about this. I let it go. I hate to interrupt her. She stated it about 5 times, and I've let it go each and every time, but I just can't continue to let this go on.
Ladies and gentlemen, both sides have the ability to call witnesses, and both sides are free to choose not to call witnesses.
Can I continue?
Please.
I didn't call him to the stand. This story is not the story I'm here to tell. So when you get this verdict form and you're asked, with respect to plaintiff's claim for fraudulent inducement, I think you should find in favor of the plaintiffs because we were fraudulently induced. The only evidence is we're in this deal because Mr. Hyder told my client he'd done this before and he could get this evidence. And my clients were induced to let him take that $457,000 at closing because he was supposed to pay for carry costs, not put it in his pocket. And with respect to the claim for conversion, and I'm going to go over this in a little bit in damages, but also find in favor of the plaintiffs because money my clients earned in rents, Mr. Hyder put in his pocket. Claimed it was an offset or a set off for a debt that's been determined my clients never owed. And he also converted that $457,000 into his pocket instead of paying carrying costs. And he also converted the money paid supposedly for Ms. Kimbrough's fees into his pocket. And he also converted some of the other money that you've seen, wires that were supposed to go for lawyers' fees. He converted the money from the Skipper fire, $300 and something thousand there. He converted the $163,000 from that was stolen by the Vittorio Group, put that in his pocket. All of that conversion, all of that unjust enrichment. So with respect to the claim for unjust enrichment, we'd like you to find in favor of our clients because it's not just the money. It's got a piece of property my clients paid for, a piece of property he himself thinks is worth $700,000. And with respect to the claim for promissory estoppel, again, we think you should find in favor of the plaintiffs because there were many promises here that we relied on. I can get you financing is the first one. What's the last one? Pay me $100,000 and I won't sue you. I promise. Clearly, we've met the elements of these claims. And set-offs don't apply because it's been determined my clients didn't owe any money to the defendants. So now I want to talk to you a little bit about the damages. Now you heard a lot about the money my clients are out of pocket in this case, most of which ended up in Mr. Hyder's pockets. And the vast majority of it ended up there improperly, but not all of it. And I want to be really clear on that, ladies and gentlemen in the jury, because Mr. Hyder legitimately earned some of the money. You'll see in some of the slides, some of the wire transfers, it'll say Skipper or Mildred, because that's money that our clients were paying so that ABG could fix up those residential properties. That's legitimate. And we didn't include that in our calculations. And examples of that are exhibits 58 and 59. Those are not included in our calculations. Also not included in our calculations are monies, the 10% management fee that the defendants earned managing those residential properties. If you do the math on those summary statements, the 10% that ABG was entitled to, not included in our damages. And we admit that. Mr. Hyder earned some money during that time period, and he was paid that money. So when we ask for our damages, we're not taking money that he earned. We legitimately recognize and leave that money on the table. But what of our rents were converted and not paid to us? You've got exhibit 251. You've got exhibit 252. You've got exhibit 253. And in this one, if you remember, Dr. Dalton was careful to point out to me that there's some legitimate money on this one. There's $7,300 that was that related to Skipper, and we backed that out. Legitimate money withheld, not part of our damages. There's exhibit 254. There's exhibit 255. There's exhibit 172. There's exhibit 171. And if you total all of those up, it's $64,584.43. And we demanded that back. Exhibit 137, we demanded that back. And Dr. Dalton told you, we didn't get it back. Instead, we got sued. But that's really just the tip of the iceberg, ladies and gentlemen. Because the evidence shows, the undisputed evidence shows that in 2016, my clients out of pocket $257,645. And you can look at the, down here we give you the exhibit number where you can get those dollars. Exhibit 34, part of the down payment. 250, part of the down payment. 54, part of the down payment. 274, part of the down payment. Now there's $5,000 to Ms. Kimbrough, which Dr. Dalton testified about. Remember, he told you he went to the bank. There was some text messages about this and he wired it right into her account. But that's before the closing. Then there's the money for the architect, the first payment for the architect, and the second payment for the architect that Dr. Dalton testified about. That's P55. And then there's 268, which is the $8,500 paid to CRE Financial, and some more money to an architect at 258, and some more money for surveying at 256. And there's more. There's exhibit 57, which is a $13,000 wire transfer that was sent to Mr. Hyder because he needed money for fees. There's the Fowler loan extension at 266. There's fees to the proposed lender IFC at 149. There's $3,000 at 251 for another appraisal. There's some of that money that's withheld for lead and asbestos, money withheld for insurance. Another Fowler loan extension. There's some more legal fees that supposedly were paid to other lawyers. There's insurance and lawn. There's more legal fees, more legal fees, more legal fees. There's consulting fees. There's another appraisal in 2017. There's actually two documents there. That's actually a repeat. Got my math wrong. 64 and 65 are the same transaction. There's more legal fees to pay the lawyer to write the threatening letter to Sam McGuire. There's $50,000 paid to Bristol. There's $10,000 that had to pay to Sam McGuire. There's more money at the end of 2017. And when you add all of this up and you take the $257,000 that Mr. Hyder pocketed at closing, and you take the $163,000 that was the partial recovery from the money stolen by the Vittorio Group, and you take the money from the fire at Verbena, the insurance money, and you add that in, you've got 1.1 million, $1,128,518.16. Over $1 million. Now, the judge is going to give you some instructions about damages and what you can and you can't consider. He's going to tell you that you can award money when you can award money that we've shown was wrongfully withheld from my clients. You can award money that you believe my clients were fraudulently induced to pay. You can award money where you think Mr. Hyder was unjustly enriched at my client's expense. And he's going to tell you that you can award damages for injury to peace, happiness, and feelings. And when you consider that, I want you to remember the evidence. Remember Exhibit 179. That email that Dr. Dalton referenced in the audio tape. An email from Mr. Hyder to Dr. Dalton on July 30, 2017, where Mr. Hyder says, you need to either, 1, get them to agree in writing to postpone the foreclosure, 2, file Chapter 11, or 3, prepare to fork over $1.2 million. Remember John's testimony about how hard he worked to keep this deal going. A deal which apparently was crippled right from the start, according to Mr. Hyder's own witness, George Andrews. But John tried, and he paid, and he paid. In the beginning, he paid because he wanted the deal. He wanted this deal. It was going to be a good deal for these business partners. But then the threats started. They started in July of 2017. The threats to sue him and his brother, not to beat him up, but to sue him. And he kept paying, and he kept paying, and he kept paying, all to avoid this. All of it. All of it. So my clients are out of pocket over $1 million. What amount of money would compensate them for everything they've had to go to? For being bullied like this, for the anxiety, the stress, all of that? John's a doctor, had to take time away from his patients. Brian had to take time away from his family while they were grieving. John's the big brother here. Mr. Kendall talked about a marriage and how this was like a marriage. That was a family. Was a family. So you need to use your common sense and figure out what you think is fair and just. Used to be that $1 million is a lot of money. It's kind of not true anymore. Times have changed, the value of money have changed. This is a case about an abuse of trust and deceptive conduct. It's about money taken but not earned. It's about lies and deception and unjust enrichment, and ultimately it's about greed. And these things cause serious damage to my clients, not just the 1.1 million to their pocketbooks, but to their lives. So what amount of money would that be? Well, as Mr. Kendall told you a bunch of times, and you heard my clients say, they think $5 million is fair. And if you think about it, if you think about a bell curve, you got 1.1 million, we're clearly out of pocket. On this end, you have Exhibit 32. What were they supposed to be getting at the end of this deal? a property worth 13 million. What's in the middle? Now, you've heard the testimony, you've seen the evidence. We believe that 5 million is fair and a reasonable award here, given everything that my clients have lost. But in the end, we leave that decision to the enlightened conscience of the ladies and gentlemen of the jury. Thank you very much for your time and attention and for trying the case with us. We look forward to getting your verdict.
Ladies and gentlemen, we've reached that point that I forecast for you before Ms. O'Neill started, which is you all, and you can confer briefly if you need to let me know, do you want to get the jury charge, which is this document that I will read to you, before you go have lunch, or do you want to go have lunch, come back and get this, and then begin your deliberations? This will be your first mini deliberation because you're going to talk amongst yourselves, and unlike your verdict, which will need to be unanimous, we'll go by majority vote here as to who wants to break for lunch because, gosh, you've been sitting and listening and absorbing for a long time, or we've got a little more in us, Judge, and so we'll take the jury charge. I'm happy either way. I want to respect your comfort and need to eat. You'll get lunch either way. That's not my point. I want to get your input on that. So use hand signals, confer. You're welcome to talk. It won't be on the record. Okay, everyone stand up a little bit and sit somewhere different. You're not going to need to see evidence. The charge will be up on the, you don't have to move somewhere different, but just stand up and move a little bit while I get ready. So there's the very real possibility that in 7 minutes I get kicked out.
Yeah.
Michelle, indeed. Yes, ma'am. Go for it. You bet. Can you see, does the big screen say jury charge on it now? All right. So this doesn't need to get on the record, what I'm about to say. There's the possibility that at 12:45, I'll get kicked out of the little Zoom session that's going right now because we have a criminal calendar that is going to start as soon as we get you to lunch and to the jury room. And it was set to start electronically at 12:45. So just let me know if all the screens turn off or all of a sudden you see the scene of the Fulton County Jail, and we'll push them off the screen and take it back over for the jury charge. I'm glad it didn't happen in the middle of either of the closings. You're very welcome. You ready? All right, ladies and gentlemen, in a moment, I'm going to give you what's called the jury charge, and I'll sit when I do it. I'm just finishing up my stretch. It's the law that you must apply to the evidence and the facts as you find them to be during your deliberations. I want to tell you two things about what I'm about to share with you. One, you'll get this document from which I'm reading. So you're welcome to take notes. But you get, along with a verdict form, which I'll show you in a moment, and all the exhibits that have been admitted that are appropriate to go out to the jury. You'll get all that, and you'll have this so you can consult it. Because, point number two, there are certain legal concepts that I am required by higher courts to describe in a particular way that may strike you as a little opaque. There's certain legalese that's going to pop in here. It's not because I normally talk that way. I don't. I've got kids and they would just make fun of me if I said the enlightened conscience of my sons. But you're going to hear things like that in here. And that's the language that the courts are required to give in explaining certain concepts. Where I'm able, I've tried to make the language more accessible, mostly for me, so I understand what I'm telling you. But please don't assume that the lawyers were trying to use big words or that I was. There are certain instructions that the higher courts have said, here's how you define topic X. And you should be able to follow along with the screen there. If I fall behind, I'm multitasking because I'll be reading more or less from this. I won't be looking at the screen so much, but as I move from item to item, I'll make sure to press the next button on my computer. And as I mentioned, in 3 minutes, I may get kicked off the screens. We'll see what happens. All right. And what I'm about to say is not on there. I know it says burden of proof. I'll get there in a second. Ladies and gentlemen, you have been considering the case of D2 Property Group, John Dalton and Brian Dalton versus Donnie Hyder, Bristol Consulting Group, and American Business Group. The plaintiffs in this case filed their claims for fraud, conversion, unjust enrichment, and promissory estoppel in connection with a failed commercial real estate development project. And the defendants have answered these charges by denying liability. The plaintiffs, now we're on the screen, plaintiffs must prove their case by what is known as a preponderance of the evidence. That is evidence sufficient to incline a reasonable and impartial mind to one side of the issue rather than the other. If neither party proves its case by a preponderance of the evidence, your verdict would be in favor of defendants because they don't have the burden, but without a money recovery for anyone. Evidence is the means by which a fact is established or disproved. Evidence includes all of the witness testimony and all of the exhibits that have been admitted. It does not include the opening statements or the closing arguments, any questions that were asked, in other words, what the lawyers were saying, or questions that you wrote on these cards. That's not evidence. Or anything else that the attorneys or I have said during the course of the proceedings. Now, during trial, you were permitted to submit questions, and those answers to the questions are evidence. But you should draw no conclusions or inferences from the fact that some of your questions may not have been asked. Questions are not evidence, only the answers are. In considering what is evidence in this case, you may use reasoning and common sense to make deductions and reach conclusions. Evidence